Hello there and welcome once again to The Verdict. Mick Cornett with Kent Meyers. We're here every week, meeting interesting people and dealing with topical issues, and today we welcome back a frequent guest.
Yes, Professor Joe Ty from the University of Oklahoma is joining us again for his 7th appearance, and he's our constitutional law expert, our Supreme Court expert, and we're going to really put him to work today.
Yeah, there's a few things going on.
We've got a lot going on with the new term just recently started a couple of weeks ago, and we are going to ask him about a bunch of criminal cases, and then we're going to finish up the show with Supreme Court ethics.
We'll get to it. It's all coming up today in The Verdict, and we'll be right back.
Right now, 6 feet can feel like a long ways away. But from 6 feet, we can still smile at each other. From our doorways and our stairways, from opposite sides of the street and opposite sides of the country. Through fear and frustrations, we can remind each other that we are still here for each other. Because we can still smile at each other. And we're not going anywhere.
Military service ran in my blood, starting from my father, which joined the Navy, on the Chickasaw side, my uncle, which served in the United States Army. I'm Benjamin Espinosa, Chief Petty Officer, United States Navy, and I'm Chickasaw. I went to the Secretary of Defense's staff at the Pentagon in Washington, D.C., which ultimately led to becoming a combat support technician for Naval Special Warfare, specifically SEAL Team 10. I think to be proud and to love your tribe, to love being Chickasaw, you also have to love being American. You also have to love everything that America stands for. Equality, perseverance, professionalism, and power. I want my family to know that their father is a good person, but also feels that he has an obligation to the country and to love this nation. Anything worth having is worth dying for. The military and the country owes me nothing. I owe it everything.
See more stories about the Chickasaw people at profilesofanation.com.
Welcome back to the set of The Verdict. Mick Cornett with Kent Meyers. Kent's going to introduce today's guest.
It's a genuine pleasure today to have back Professor Joe Ty from the University of Oklahoma. I've known Joe for many years, and this is, as I said, his 7th appearance on our show. We really do like having him, and he does a grand job, and I know he will today as well. Just as a reminder, Joe did his undergraduate work at Harvard, did his law work at Harvard, is now at the University of Oklahoma and has been for a number of years, where he teaches constitutional law and Supreme Court of the United States practice. He was a law clerk for 2 United States Supreme Court justices, Justice White and Justice
John Paul Stevens.
Stevens, yeah, how could I forget Justice Stevens? Yeah, Justice White and Justice Stevens. He is an outstanding teacher of the law. He is well recognized from the university standpoint of being a leader at the university. And we're sure pleased to have you back, Joe.
Well, it's great to be back, and now I have 7 of these coffee mugs, so one for every day of the week.
Well, if you get a couple more, we'll buy them back from you.
All right.
Well, I know, Joe, that one thing that has caught most of the public's interest is the litigation around the former president. And there are an awful lot of cases going on, and I thought maybe if you could give us a little primer on each one about what it's about, what is the risk exposure, what is the timing involved, and how does one case perhaps affect another. I think it would be useful to our viewers. So,
Sure.
So just take off.
Yeah, well, it takes almost a full-time job to keep track of them, so it's a good thing that I'm on sabbatical. I hate to use the word unprecedented because it's become cliche in relation to the former president, but this is literally unprecedented that we have criminal charges against a former president of the United States, and not just in one case, but in 4 cases for a total of 91 felony charges. So there's the classified documents case in Florida. There is the election obstruction case in D.C. Those are 2 federal criminal cases. Then there is a state civil conspiracy case in Georgia and a state case involving hush money payments in New York City. So I'll be happy to walk you through each one of those when you want, in whatever order you want.
Well, let's just take them in the order in which you mentioned them.
Okay, yeah, probably the simplest is the one in Florida, which is, the allegation that he had these classified top secret documents at Mar-a-Lago, and the allegations are that he knowingly withheld them and obstructed the attempts by the National Archives and the FBI to get them back. And he's raised a number of federal defenses against those charges. One is based on executive power, that he had the power to just declassify them by thinking about them as declassified, and that he essentially did that before he took the documents to Florida. The other defense is executive privilege, that he's entitled to preserve the confidentiality of the documents that he took based upon his executive privilege as the former president.
Well, let's say that we're dealing with a document that is clearly classified.
Right.
Say it's a top secret. And it's something that came within his possession while he was president. He dealt with it. He kept it in his desk for future reference for whatever reason.
Sure.
When he leaves, is he not entitled to take that with him?
Well, this is unprecedented. Presidential documents by a law of Congress actually belong to the country, not to the president, and so they normally go to the National Archives, but he's contending that he's declassified them, so one, there's no sort of national secrets problem with them, and 2, to the extent that they're not his, he only inadvertently took them to Florida, not intentionally.
Are these physical documents like pieces of paper, or are they digital documents? Do we know?
These are physical documents, pieces of paper with classified stamped on top of them. They were in boxes, some of them in the ballroom, some of them in the bathroom in Mar-a-Lago. Of course, he had dozens and dozens of boxes, so part of his defense is that he didn't know what was all in them, and that it was his aides that were moving them around, and so he wasn't aware.
What about, did he have any in his personal desk or anything like that?
Well, they found some in sort of the office area where he works at Mar-a-Lago.
Oh,
right. And the contention that he's making is executive privilege, that in other words, when he was president, certainly he was entitled to the confidentiality of the advice he got, including the documents he got, national security briefings. But it's really unprecedented for a former president to claim that he still has that privilege and it still is entitled to access to those documents.
What is the current status of that case? How is it progressing?
It's going to go to trial scheduled in May, but you know how things go with trial lawyers. And Trump's
and that would be tried in Florida?
In Florida, in federal district court. And Trump's team is going to try to slow play this as much as possible, possibly beyond the 2024 election, which of course would set up another potential constitutional issue that's unprecedented, which is, can the former president pardon himself once he becomes president? In order to stop all of these prosecutions in their tracks.
Any law on that?
Well, Article 2 of the Constitution gives the president the pardon power, but doesn't specify who he cannot pardon. And so there are arguments for and against the president pardoning himself. One is that the language doesn't say he cannot, but then on the other side, there's the structural separation of powers, checks and balances argument that surely the president can't pardon himself because then there wouldn't be a check on the president.
From a standpoint of criminal exposure, do you recall just approximately how many criminal counts are in the Florida documents case?
I think there's potentially one count for every document that's classified that he allegedly attempted to withhold or obstruct their finding by federal officials. I forget how many there are, certainly more than a dozen.
Oh, okay. So it's a significant.
Yes.
And the penalty is severe?
These are felonies, and so we're talking years in prison.
Yeah.
Yeah.
All right, let's move to Georgia, just one state over, but an entirely different issue.
Well, you can't accuse the president of being boring, right? So in Georgia, the allegation by state officials is that there's this vast criminal conspiracy, 19 co-defendants, including not just the president, but Giuliani, his former lawyer and former America's mayor, and also Mark Meadows, his former chief of staff. And the allegation is that these conspirators engaged in a criminal conspiracy to pressure state officials to overturn the results of the election which Biden won in the state so that Trump could be certified as the winner. And there's this famous or infamous phone call that Trump made to the Secretary of State in Georgia asking him to find the votes for him to flip the outcome.
So it's against the law to pressure somebody.
Well, so Trump's allegation, or Trump's defense in the case, is that he exercised his First Amendment rights to pressure state officials to find election fraud and to find valid votes for him. But the allegation that the prosecutors are making is that, no, he lost the election. What he was pressuring the state officials to do was essentially to illegally ignore the outcome of the votes and to basically hand him the win.
And he was president at the time that these conversations allegedly took.
Exactly so. And Mark Meadows was the chief of staff at the time, and so part of their federal defense is that they were acting within the scope of their employment duties, and so they're entitled to immunity because the president can't be sued for doing his job as the president. The counter argument is, well, it's not the president's job to try to flip the outcome of an election that went the other way.
And this, I'm sorry, go
I
ahead.
was just going to say, where will that case be tried?
It's going to be tried in state court in Georgia. I believe the trial is happening in March.
In Fulton County.
In Fulton County, which is around Super Tuesday. So it's going to be a wild election season where we have Trump in court and then also Trump running in the primaries. Ultimately, these issues will go up to the U.S. Supreme Court.
Let me ask you, we just have about 30 seconds left before we need to take a break. Does the Florida state case include the issue about the electors?
No, that is the Georgia case and also the federal case brought in D.C. for his efforts to pressure Mike Pence, and that's right, to prevent the certification or to accept the alternative slate of electors for him from Georgia, Michigan, and other states.
Well, you can already see that 2024 is going to be wild and crazy.
Oh, it is, and the Supreme Court's going to be dragged back into this.
Joe Ty is our guest. We'll be right back on The Verdict.
Very good.
At Whitten Burridge, we're litigators. That's all we do. All of our clients, some sort of wrong has occurred to them. We try to right that wrong. Corporate America, they have all the power. It's sort of like going against an army. I like helping the underdog. That's what gets me up out of bed every day.
Our success rate is phenomenal, but that's not all they get. We care about people.
I'm very proud of what we've been able to do for our clients, and I'm looking forward to what we're going to do in the future. There's still a lot of wrongs that need to be righted.
OU Law has a history and heritage that are unparalleled. At the University of Oklahoma College of Law, we empower our students to pursue the career of their dreams. We have the highest U.S. News ranking ever achieved by an Oklahoma law school. We are the first law school in the country to launch a college-wide digital initiative. And this year, our competition teams ranked number 2 in the nation. OU Law, generations of excellence, limitless possibilities.
One of the best kept secrets about the post 9/11 GI Bill benefit is that it can be used at a trade school or a technical school, and it doesn't have to be used at a university or college. These are benefits that the veterans have earned through their service, and they should take advantage of it.
Veterans really need to understand that there are many resources offered by the Oklahoma Department of Veteran Affairs. They are there to help you find the right school for you, the school that will help you and your family make great steps into your future.
We're back on The Verdict. Mick Cornett, Kent Meyers, and our guest, Joe Ty.
Joe, let's switch gears now and talk about what we will shorthand as the January 6th case, and kind of tell us what conduct allegedly violating criminal law is covered by the named January 6th case?
Sure, that's the case brought by the special counsel appointed by the Attorney General, Jack Smith, and it's in federal court in D.C., and the allegation is that President Trump and his co-conspirators conspired to and attempted to obstruct the certification of the January 6th election, the January 6th certification of the 2020 election for President Biden. And the allegations are that there's a pressure campaign to get Mike Pence to either stop the certification or to throw the certification to President Trump and accept alternative slates of electors from states that Biden won.
Well, approximately how many counts are involved in the January 6th case?
I believe there's actually about 4 counts because Jack Smith was laser focused on not making that case big and sprawling, and because he wants it to go fast before the 2024 election.
Now, this does not include any of the individual claims against people who were at the Capitol and who got charged with criminal conduct and have already pled or been sentenced or in process.
No, those are separate criminal cases against them. The special prosecutor was laser focused on Trump to get this case going as quickly as possible. And Trump has some interesting First Amendment defenses.
Yeah, let's talk about those.
Yeah, so he's going to claim, I think, a couple of things. One is that he was just engaging in political rhetoric. Whether or not it's true or false that he won the election or lost the election, he's going to claim he sincerely thought that he won the election, and so he was engaging in political speech to protect his victory, which was being subverted. And even if his speech was false, and even if he was advocating illegal action for Pence to stop or to subvert the certification, there's strong First Amendment protection, not only for false political speech, but for advocacy of illegal activity. There's this doctrine called incitement that says, incitement is protected speech unless you're inciting imminent lawless action, knowingly inciting imminent lawless action. So the question is, does his speech fit, that definition?
Well, you're reading my mind, because as you were talking, I was writing inciting a riot. Is that included in the January 6th case?
Well, there's the maxim that everyone has heard that you can't yell fire in a crowded theater, right? Yeah. And so the question is his political speech, for example, at the rally at the beginning of January 6th, is that the equivalent of yelling fire in a crowded theater, or is that just, giving a heated political talk?
Mm-hmm. Was it a political protest that got out of hand?
That's right.
Yeah, sort of that line of thinking.
That's right. Versus, was he specifically intending to send the mob over to the Capitol to stop the certification?
Well,
and the vice president is not being charged in any through all of this cases, right? Okay.
No. In fact, he could be the star witness, which would really be interesting because, of course, he's also running for president.
Yeah. When do you expect, or has the January 6th case been set for trial?
Yes, it's been set for trial, I believe, in beginning or end of March. I forget which one. It's hard to keep these cases straight. 2024. Yeah.
Okay.
Yeah.
Well, and this couldn't be the first time this has happened, that a person has had charges against them from multiple jurisdictions, and they start overlapping. Is there ever a point where a person can say, look, one at a time?
They can, and they do, and
they will.
And they will, and typically judges are mindful of spreading them out enough to give them enough time to prepare for each of those cases. Of course, this is an extraordinary situation because of the time pressure of November 2024, the presidential elections. And so I think the judges are mindful of, well, if they push the trial dates beyond 2024 and Trump wins, then the issue may become moot or it would set off a potential constitutional crisis because he may attempt to just pardon himself.
The next one I want to talk about is the hush money case. This is the fourth criminal matter.
That's right, and it's the second state criminal case against him. And so, there's nothing illegal about making hush money payments to an alleged mistress, right? What makes this allegedly criminal conduct is falsifying business records in order to hide those payments as legal expenses. And the allegation that state prosecutors are making is that it's actually to hide a campaign contribution, because the hush money payments was valuable for the Trump campaign. They were made just weeks before the 2020 election, and so they should have been reported on federal disclosures.
So the allegation is they used campaign funds to pay the hush money.
Oh, no, that it was the Trump organization that paid, and also Trump who paid out of his own pockets, but Cohen was the one that actually facilitated the payments. And to the extent that it added value to the political campaign of then candidate Trump, it should have counted as a campaign contribution.
I see. And so was this a business expense that is that how they reported it?
They reported it as a business expense under state law, and so the allegation is that that's false, because it really was the equivalent of a campaign contribution.
And so is there precedent that you can't make a hush money a business expense? It has to be a personal expense. Is that the way it's defined?
Right. So the question really is, one, is that a false business record to say that this is a business expense, to tamp down negative press, versus was it really a campaign contribution?
So is this a case that violates tax law or violates campaign finance law?
They did not allege that it violated tax law, but they are alleging that it violated federal campaign finance law, because on the federal side, of course, there are limits to how much money you can give to a candidate, and $130,000 is over $100,000 over the limit.
When is this case scheduled to go to trial?
This one is scheduled to go to trial in March as well. So the January 6th case in D.C. and the hush money case in New York are both going to trial in March, one at the beginning, one at the end.
Yeah, it's likely one of them is going to be pushed.
I think so.
Yeah.
Now, who are his attorneys, the former president? Does he have separate attorney groups for each of those four?
Yes and no. He has different attorney teams for each group, but some of the attorneys are representing him in multiple cases. I believe one of them in the Florida case is also in one of the New York cases. He's having a hard time, quite frankly, finding attorneys for all of these cases, because they take a massive legal team.
Let's change topics and go to Supreme Court ethics. And it's a big shift, but we've only got a couple of minutes.
Sure.
So can you give us kind of a summary on what's going on about a possible code of professional responsibility for the United States Supreme Court?
Sure, there are none. So the federal judges that serve in the circuit courts, the appeals courts, and in the trial courts, the district courts, they're bound by the judicial code of conduct that they adopted in the 1970s. But the Supreme Court has never adopted a code of conduct for the justices. So each justice is a law unto themselves as to whether or not they should recuse and what their ethics are.
Well, that is not each justice subject to the law of the state in which they are licensed to practice?
Well, they are, but they're not practicing anymore. So that's a scarecrow of a sanction to say that they would be, disbarred from practice in any state. And when I worked at the court, I don't want to date myself, but let's just say over 20 years ago, there were just arguments floated by some of the justices against adopting a judicial code of conduct for themselves, even back then. And some of the arguments I heard, I frankly think are spurious. One of them is that, well, there's only 9 of us. And so if we recuse ourselves, there won't be enough of us to do our job. But the Supreme Court back in the early 1800s only had 6, the Marshall Court, and they issued some of the most important decisions that the Supreme Court has ever issued.
Well, there are procedures for having somebody sit on the Supreme Court, even though they're not a Supreme Court justice.
Actually not.
There's not.
There's not, but there could be. Congress could, pass a law that says, some lower court judge could sit by designation on the U.S. Supreme Court.
Joe, we're going to need to have you back in the spring and continue to sort all this out for us.
Happy to.
All right.
We'll keep a scorecard.
Fascinating show. We'll be right back with the final word after this.
This is the epidemic of my generation. This is my HIV. This is my Black Plague.
In the midst of one of our state's largest crises,
Oklahomans are dying from this preventable and treatable disease on a daily basis.
we believe there's hope.
That little pill will cause destruction through your whole life.
Watch the entire award-winning 9-part docuseries Killing Pain, made available by Fighting Addiction Through Education at killingpain.com.
It used to be okay in teachers' lounges. It used to be okay in maternity wards. It was okay in sporting arenas, college campuses, and office spaces. But now that we understand the deadly dangers of secondhand smoke, that's not okay anymore. So why is it okay that thousands of employees are exposed to it every day at work? Bottom line, it's not okay. Let's protect hardworking Oklahomans. Join the fight at stopswithme.com.
All children deserve a life of hope and love, but sometimes they experience a life of pain, neglect, and abuse.
When that happens, each child deserves all the quality assistance and representation that can be offered in our legal system. For more information, call 23-CHILD.
Oklahoma Lawyers for Children, helping to bring hope and love back to the lives of abused children.
You will always be mom and dad to me.
I think for us, once we got started and we began to see the tremendous need just within our state, it really was just a calling for us. The blessings far outweigh obstacles that we've faced.
You will always be mom and dad to me.
We really appreciate Joe coming on the show. He on a sabbatical, but took a break from that to come to see us.
Yeah, he's great. We got to have him back.
And a thorough examination of all 4 issues and other things that the Supreme Court's working on. So I hope our viewers appreciated his time and your time. We certainly do. You can get more information about Joe and his work at law.ou.edu. And we have a website, theverdict.tv. We'll see you next week on The Verdict.